All right, good morning, everyone. This meeting is called to order. Mr. Trobman, has anyone signed up for public comment?
Morning, Commissioners. Les Trotman, General Counsel. We have one individual who has registered for public comment. We have Christy Lawrence. Ms. Lawrence, if you're there, go ahead and unmute yourself and begin.
Hi, good morning. I'm not sure how this process works, but this comment is due to the findings and facts and Jay Killian's decision on my appeal. I feel like my evidence and my exhibits C3, 4, and 5 in my previous write-ups in November of 2023 that were dismissed by the Board of Directors for being false allegations a few months prior to this was no interest to the hearing officer, Jay Killian. I feel like I couldn't rebut the accusations from Ms. Pearson when she stated them or when he asked me to ask her questions and she wasn't telling the truth. She was not truthful throughout the whole hearing. I do not believe that is a fair hearing. The facts on this reprimand are not true. I believe that is why Josie altered the write-up with the last paragraph on the reprimand that if I refuse to sign, then I am resigning my position before it was sent to the president of the board on May the 3rd. 4 days after I requested a copy of it, and that is why it was dated April 30th, the day I requested it from her. I believe that may be why the board didn't grant my grievance because they were told and believe I resigned. I honestly believe that by filing a grievance and bringing the facts about the false incident listed on the reprimand, it would have been dismissed and the retaliation from the office manager would have been addressed, and that is why I refused to sign it because this is not her first time doing this. Also, in our employee policy, it states that a written reprimand in your personnel file can inflict on raises, bonuses, and promotions. It does not state that you can and will be terminated if you refuse to sign a written reprimand. An employee has rights and shouldn't be forced to sign a falsified document or lose their job. If I had the opportunity to have gone before the board, I believe they would not have allowed her to terminate me and I would still have my job. Thank you.
Thank you. Commissioners, those are the comments we have this morning.
Thank you, sir. On agenda item 3, we have no cases to reconsider. Is that correct?
That is correct.
Under agenda item 4, tax liability cases, we have one case on docket 20.
Good morning. For the record, Hugh Daniel, Special Program Appeals. That is correct, Chairman Daniel. There is one tax liability case in docket 20. The case number is 25-003-0125. Commissioner Esparza.
I agree in part and disagree in part with the staff's recommendations. I agree that all of the workers except for the data entry specialists and the installation services workers are not in employment. I also agree that the installation services workers were in employment. However, the data entry specialist was an employee during the entire time she performed such work for the company. She had ordinary clerical duties that were directly integrated into the company's business operation, was eventually converted to a regular employee with no change in duties, and there was no evidence that she owned and operated her own company or otherwise conducted herself as an independent business enterprise. Thus, except as to the data entry specialist, I agree with the staff recommendation. The data entry specialist was in employment.
Commissioner Trevino
I'll agree with Commissioner Esparza.
and Chairman Daniel.
Agree with staff recommendation.
So we do have 2 votes.
Short form dissent.
Thank you. That concludes the tax liability cases for this docket.
All right. No fair housing cases on agenda item 5, no child labor cases on agenda item 6. Under agenda item 7, while we have no wage claim cases on docket 20 pulled for additional discussion.
That is correct. However, there are remaining cases to be voted for the wage claims on docket 20. You should have received the short form dissent list for the wage claims.
Nobody accept staff recommendations on the remaining wage claim cases on docket 20.
I second the motion except for those cases which I am dissenting as reflected on wage claim short form dissent list for docket 20.
I concur with the chairman's motion except for the cases in which I'm dissenting. as reflected in wage claim short form dissent list for docket 20.
Motion passes with the exceptions noted. Let's move to agenda item 8 in consideration of unemployment insurance cases on docket 20.
Case number 3122012, Commissioner Trevino.
While the claimant filed her appeal to the commission after the deadline, this case involves a continued claim related to the claimant working as a marketplace contractor in self-employment. As such, there is no separation from employment, and the continued claim should be voided. Deem the claimant CA appeal timely, set aside the AT decision, void the continued claim.
We should dismiss the claimant's CA appeal as late. The claimant filed her appeal well after the applicable deadline for timely appeal. So there are no good cause exceptions for timeliness rules. We should dismiss the claimant's CA appeal as late and leave the underlying AT decision in full force and effect. Valid claim, voluntary leaving, overpayment.
Deem commission appeal timely, resubmit.
Ma'am, I'll agree with the chairman.
Thank you. We will resubmit the case.
Case number 3605772, Commissioner Esparza.
The AT decision on good cause should be reversed. The employer testified that it was unable to attend the AT hearing due to a family medical emergency. The employer should not be faulted for being unwilling to disclose private details of a family medical emergency. In addition, the employer stated that no one else with the employer could call into the meeting. As such, the employer was prevented from attending the hearing due to circumstances beyond its control, and we should find that the employer had good cause for its non-appearance and resubmit the case for merits testimony.
The AT decision is correct. Regarding the employer's failure to appear at AT1, the employer's witness provided inconsistent and conflicting reasons for missing the hearing. Therefore, the employer has failed to establish good cause for missing AT1, and their petition to reopen should be denied. Affirm the AT, employer did not establish good cause for AT1, valid claim, no misconduct.
Valid claim, no good cause, no misconduct.
A short form dissent.
I have your short form dissent.
Case number 3605784, Commissioner Esparza.
The AT decision on good cause should be reversed. The employer testified that it was unable to attend the AT hearing due to a family medical emergency. The employer should not be faulted for being unwilling to disclose private details of a family medical emergency. As such, the employer was prevented from attending the hearing due to circumstances beyond its control, and we should find that the employer had good cause for its non-appearance and resubmit the case for merits testimony.
The AT decision is correct. As in the prior case, the employer's witness provided inconsistent and conflicting reasons for missing the hearing. Therefore, the employer has failed to establish good cause for missing AT1, and their petition to reopen should be denied. Affirm the AT, employer did not establish good cause for AT1, suitable work eligible.
No good cause, no suitable work disqualification.
Short form dissent.
Case number 3651539, Commissioner Trevino.
The decision is not correct. The employer discharged the claimant for violating its code of conduct policy and alleged that he used company equipment to access inappropriate material on the internet. The claimant provided sworn firsthand testimony denying the employer's allegations that he accessed or viewed any inappropriate websites on his work laptop. The claimant also explained that his search history from his personal computer transferred over to his work laptop because he was signed into his Google account on both computers. Since the employer was unable to provide any direct evidence that the claimant used his work computer and not his personal laptop to view inappropriate websites, the employer has failed to carry its burden of proving that the claimant's actions constituted misconduct connected with the work. Reverse the AT, no misconduct, chargeback.
We should affirm the AT decision. The employer code of conduct required appropriate and respectful use of electronic equipment, specifically prohibiting access to or distribution of obscene or offensive media. Claimant was terminated when he used the employer-issued laptop to access an adult-themed website on multiple occasions. The employer investigative report established that the laptop assigned to the claimant was used to access the prohibited website, and a connection was made between the laptop and the website. Further, the evidence showed that the claimant accessed the website frequently during work hours. Since the evidence overwhelmingly demonstrates that the claimant violated company policy by using employee resources to access inappropriate materials during work and non-work hours, this conduct constituted misconduct connected with the work. As such, we should affirm the AT decision. Misconduct, no chargeback.
Misconduct, no chargeback.
Short form dissent, ma'am.
I have your short form dissent.
Case number 3669964, Commissioner Trevino.
The AT decision should be modified. I agree that the claimant established good cause for her failure to appear at AT1. However, regarding the job separation, the claimant denied the allegations that she mistreated coworkers or used profanity. Though the claimant admitted to raising her voice in the final incident, she clarified this was only in response to her coworker becoming upset by the claimant's reasonable questions about work duties. The employer provided no firsthand testimony to support their allegations of misconduct. Therefore, the employer has failed to meet its burden of proving that the claimant engaged in actions that could be considered misconduct connected with the work. Modify the AT, claimant established good cause for AT1, no misconduct, chargeback.
We should modify the AT decision. First, I don't contest the good cause issue concerning job separation. The claimant was terminated for violating the employer's anti-harassment and bullying policy. The claimant was previously counseled for performance-related matters. Despite this, the claimant was subsequently observed yelling at a coworker and speaking over them in a rude and condescending tone. Given that the claimant was on a final warning and had received prior counseling regarding her conduct, her repeated unprofessional behavior constituted misconduct connected with the work. As such, we should modify the AT decision. The claimant established good cause for missing the AT hearing, misconduct, no chargeback, adequate employer response.
Good cause. Rehear for employer firsthand testimony.
We'll go with the, I'll agree with the chairman.
Thank you. We will rehear the case.
Case number 3676395, Commissioner Esparza.
The commission should grant a rehearing in this case. In its appeal to the commission, the employer has offered to bring firsthand knowledge of the incident leading up to termination. Since the final incident consisted of the claimant being belligerent and combative with a manager, firsthand knowledge of this event would be critical for a proper disposition of the case. We should therefore rehear the case for firsthand testimony from the employer.
The AT decision is correct. The employer discharged the claimant for allegedly being combative when questioned by her manager about an incident with a vendor. The claimant denied the allegations of misconduct under oath, and the employer only offered vague secondhand evidence about the claimant's actions. Therefore, it was properly concluded that the employer did not carry its burden of proving that the claimant was discharged for misconduct connected with the work. Affirm the AT, no misconduct, chargeback.
Rehear.
We will rehear the case.
Case number 3696997, Commissioner Trevino.
The AT decision is not supportable. The claimant's claim was dated 3/29/20, and the claimant stopped filing payment requests in September of 2020. Yet the determinations at issue in this case were not sent until 12/14/21. The claimant could not be expected to timely respond to the documentation sent to her by the commission on an indefinite basis. This delay in issuing the determination constituted commission misinformation sufficient to deem the claimant's appeal timely and remand the case for merits testimony. Reverse the AT, timely claimant appeal, remand.
We should reverse the AT decision on timeliness, timely claimant appeal, and remand the case for merits testimony.
Timely appeal, remand.
Thank you. We will remand the case.
Case number 3697000, Commissioner Trevino.
The AT decision is not supportable. As in the prior case, the claimant's claim was dated 3/29/20, and the claimant stopped filing payment request in September of 2020. Yet the determination at issue in this case was not sent until 12/21 of 21. The claimant could not be expected to timely respond to the documentation sent to her by a commission on an indefinite basis. This delay in issuing the determination constituted commission misinformation sufficient to deem the claimant's appeal timely and remand the case for merits testimony. Reverse the AT, timely claimant appeal, remand.
We should reverse the AT decision on timeliness, timely claimant appeal, and remand the case for merits testimony.
Timely appeal, remand.
Thank you. We will remand the case. That was the last pulled case for UI cases on docket 20. You should have received the short form dissent list for the remaining cases on docket 20.
I move we accept staff recommendations on the remaining UI cases on docket 20.
I second the motion except for those cases which I am dissenting as reflected on UI short form dissent list for docket 20.
I concur with the chairman's motion, except for the cases on which I'm dissenting as reflected in UI short form dissent list for docket 20.
Motion passes with the exceptions noted. We'll take a short recess.
Thank you.
And we're back. It's agenda item 9. We owe a local workforce development board plans for program years 2025 through 2028.
Good morning, Chairman, Commissioners, Mr. Townsend. For the record, I'm Joel Mullins with Workforce Development. Under Workforce Innovation and Opportunity Act, Section 108, each of the 28 local workforce development boards must develop and submit a comprehensive 4-year plan, and the plans must be approved by the governor. Texas Labor Code, Section 302042 requires the commission to review local plans and make recommendations to the Texas Workforce Investment Council regarding the implementation of those plans. TWC staff members have reviewed the submitted local plans and provided feedback to boards, and staff have concluded that full review process and have determined that all 28 of the local plans comply with all federal and state requirements. This morning, staff recommends submission of the 28 local plans to the Texas Workforce Investment Council for consideration and recommendation to the governor for approval. And I'll be happy to answer any questions.
Any comments or questions?
None here.
No, no question.
A couple questions. So as I understand law, and I want to make sure you understand the same way, under both WIOA and the government code, the commission's role here is to review these and then recommend them to the governor for approval. Is that basically correct?
That is exactly correct.
So the approval will actually come from the governor. The commission's not approving them. We're just simply passing these along and saying these are ready to be approved.
Correct. Yes.
As we reviewed these, I am assuming, I guess in keeping with both the labor code, looks like the government code, looks like some federal regulation, also some federal law, that one of the things we've done is to review these for basic compliance with all relative laws. And I just want to make sure that we have done that part. I read through several of them. They seem to comply to me, that we had an eye for that. But in particular, I want to know, were we also thinking about, so you've got, obviously federal and state law, you've got federal and state regulation. I just want to make sure also that we covered any gubernatorial or presidential executive orders, particularly those concerning the distribution of government services and for whom government services would be provided.
Yes, we did review all of that, reviewed to ensure that they were complying with all of the requirements in federal statute and regulation and state statute. And we looked at the presidential executive orders and directives from the governor and
Great, thank you very
ensured
much.
that all plans were compliant.
Good. Any other comments or questions? Is there a motion?
Chairman, I move that we approve the 28 local workforce development boards 4-year plans for submission to the Texas Workforce Investment Council as recommended today by staff.
I second.
It's been moved second, votes unanimous, motion carries.
Thank you.
Agenda item 10, Jet Advisory Board recommendation for fiscal year 2025 jet grant awards.
Good morning, Chairman, Commissioners, and Mr. Townsend. For the record, I'm Lori Knight with the Workforce Development Division. The Texas Workforce Commission was appropriated approximately $15 million for fiscal year 25 for use with the Jobs and Education for Texans or JET grant. On April 30th of this year, the JET Grant Advisory Board met to determine recommendations to the commission, and they want to direct staff to move forward with awarding grants based on the final evaluation scores with ability to move down the list for all applicants scoring 600 points or above, should any additional funds become available during the contracting phase. Staff recommends approval for the FY25 JET Grant Program Awards as recommended by the JET Advisory Board. And I can answer any questions.
Any comments or question?
None here.
No question.
All right, is there a motion?
Chairman, I move that we approve the Jobs and Education for Texans Grant Awards for fiscal year 2025 as recommended by the JET Advisory Board and in conformity with the final evaluation scoring, and allow staff the ability to move down the list of applicants scoring 60 points and above as funds become available during the contracting phase.
I second.
It's been moved and seconded, the vote unanimous, motion carries. This is agenda item 11, Jet Advisory Board recommendation for FY 2026 program parameters.
Once again, Lori Knight for the record with Workforce Development. So as the JET Advisory Board met on April 30th, they also discussed the following recommendations for FY26 JET program parameters and funding allocations. They want to split the funding available 30% for institutions of higher education and 65% towards open enrollment charter schools and school districts. They want to keep the minimum and maximum grant request amounts at $40,000 and $375,000 respectively. They would like to continue to allow only one application submission per eligible applicant. And finally, to keep the minimum score threshold for award eligibility at 60% of all possible points. Staff recommends the adoption and implementation of the program parameters for FY26 as recommended by the JET Advisory Board.
Comments or questions?
None here.
No questions.
A motion?
Chairman, I move that we adopt the Jobs and Education for Texans program funding and parameters for fiscal year 2026 as recommended by the JET Advisory Board and described in the discussion paper presented today by staff.
Second.
Been moved and seconded. Votes unanimous. The motion carries.
Thank you.
Thank you. Agenda item 12, Adult Education and Literacy Advisory Committee membership.
Good morning, Chairman Daniel, Commissioner Trevino, Commissioner Esparza, and Mr. Townsend. For the record, Carrie Ballast, Workforce Development Division. Texas Labor Code, Chapter 315.005, and Texas Administrative Code, Chapter 805.43, require the Texas Workforce Commission to establish an Adult Education and Literacy Advisory Committee. The advisory committee must not be composed of more than 9 members and must include at least one representative of the business community and one representative of a local workforce development board. There is also latitude for the commission to approve an additional 2-year term for any member. For your consideration today, staff recommends the reappointment of 2 members, Dr. Ben Stafford, Vice President of Workforce and Continuing Education at Lamar State College, and Christina Hartman, Superintendent of Wyndham School District. If approved, their terms will be extended to May of 2027. This concludes my remarks, and I'm happy to answer any questions.
Any comments or questions?
None here.
No questions.
Is there a motion?
Chairman, I move that we appoint the following individuals to serve on the Adult Education and Literacy Advisory Committee for a 2-year term expiring in May of 2027. Dr. Ben Stafford and Christina Hartman.
I second.
It's been moved and seconded. The vote is unanimous and the motion carries. Thank you. This is agenda item 13, Local Workforce Board nominations.
Good morning, Chairman, Commissioners, Mr. Townsend. For the record, Les Trobman, General Counsel. Today, for your consideration, we have Workforce Board nominees for Workforce Solutions, Concho Valley, Heart of Texas, North Texas, Coastal Bend, and Texoma. Staff recommends approval on the presented nominees, and I'm here to attempt to answer any questions which you may have. Thank you.
Are there any comments or questions?
Since you offered to attempt to answer any questions, as we discussed earlier, Mr. Trobman, how do you remove a tick?
There's a tool for that.
Okay. That's all I have.
So the somewhat evasive answer, Commissioner.
Very evasive.
Poor Mr. Trobman had to substitute at the last minute to do the nominations, and now we're treating him like this is his first time to appear before the committee.
They don't teach that in law school.
Do they teach that in law school?
Remove a tick.
I don't know.
No, but it's a good law school.
Did they cover that at
response.
Tulane Law
You
School?
just have to learn the hard way.
Oh, that's like a lot of good lessons in life. I think you just have to learn the hard way. All right. Is there any other questions or comments?
No questions from me.
All right. Is there a motion?
Chairman, I move that we approve the local workforce development board member nominees presented today for the following: Workforce Solutions, Concho Valley, Heart of Texas, North Texas, Coastal Bend, and Texoma.
I second.
It's been moved and seconded. The vote unanimous and the motion carries.
Thank you.
Mr. Townsend.
Well, since it'd be so hard to top that one, I think I'll just say no director's report.
No executive director's
No.
report. I was thrown off by a minute because there is sort of a mysterious figure sitting on the back row wearing a tie today, which sort of triggered me to believe we were going to have a legislative report. But then I realized it was Lowell, and he's declined so many times in the past to come give a legislative report. So I think we'll respect his wishes and not call him up today to do that. Is there any other order of business come before the commission today?
None here.
None? Is there a motion to adjourn?
Chairman, I move to adjourn.
Second.
Been moved and seconded to adjourn. That vote's certainly unanimous, and we are adjourned.